Thank you everybody for coming. Can I just ask for apologies for absence to start with, please? No, none at all. Thank you very much. And item 2, disclosures of personal and prejudicial interests. So,
yes, Chair. Yes, Chair. I've just talked to the monitoring officer, and she says that I would have a personal or prejudicial interest on item 5. So I will have to leave the meeting after item 3 and then rejoin for item 6.
Thank you very much, Mike. Thank you. Anybody else? No? Thank you very much. Hearings procedure, is that you, Tracy? Or?
Yes, thank you, Chair. It's been a long time coming to you, but this is the final version actually. It was held up slightly during COVID, but also I wanted to tweak it following some fairly recent guidance from the Adjudication Panel for Wales. I'm not proposing to go through it in any great detail. It may be for some of you quite a difficult read because it is talking about processes, and it's always very difficult to talk about a process when you actually haven't gone through it yourself. And one thing that you often learn is when I think we would learn if we were to have a hearing, it may be that after that hearing we would need to go back to this document and tweak it. But it is one of those things, and having spoken to many monitoring officers that have dealt with hearings that have been referred to them by the Ombudsman for Wales, they learn from their procedure and they tweak the procedure after the event. So it may be that we'll need to do this, but I mean, hopefully it does make sense to you. I'll just go through a couple of points that I really wanted to draw to your attention. So just starting off in terms of the background, it talks about 2 avenues of a report coming to you. That can either be with the Ombudsman ceasing an investigation and asking myself to undertake an investigation. They are incredibly rare. I have to say, I don't know of any monitoring officers in the last few years that have had to do that. But normally what would happen is that a breach is referred to the Ombudsman. The Ombudsman would then investigate it. The Ombudsman's investigator would provide a report, and that report would be sent to the monitoring officer with a request that the report be sent on to the Standards Committee for adjudication. So those are the 2 avenues that a report can come to you, and I'm only raising that because you may have noticed that throughout the procedure there is reference to an investigating officer. So that investigating officer may either be the Ombudsman officer themselves, or it may be myself if it were referred to me as monitoring officer. Just in relation to paragraph 2, we talk about an initial determination. So the first thing that the Standards Committee would need to do once they received an investigation report would be to make an initial determination that either there's no evidence of a failure to comply with code of conduct, or that any person who is the subject of the investigation should be given the opportunity to make representations before the Standards Committee in respect of the findings of that investigation report. So that would be your first stage. It would be an initial determination. If the initial determination was that the matter needs to proceed and the councillor who is the subject of complaint needs to appear in front of the hearing, then you need to then go on to make all the relevant arrangements which are set out in all the following paragraphs. And again, that's not what I'm proposing to take through in any great detail with you. They cover quite a range of areas in terms of the legal advice that you might receive, public access to the hearings, and failure of a party to attend a hearing. Now, that is a problem that some monitoring officers have had, where councillors simply referred to attend, so I have put something in around that so that we could deal with that eventuality if it did arise. Paragraph 9 and onwards then talks about the procedure at the hearings. Paragraph 10 talks about the stage 1. So I've broken this down actually into 3 stages, and I just think it read a little bit better. So stage one would be your initial finding of fact. So you'd hear all the evidence, you decide what view you came to as to what actually happened. So what we term as lawyers as findings of fact. So you determine what those are. Then once you've made those findings, you then go on to stage two. And the consideration there is whether or not the councillor failed to follow the code of conduct. So you'd be looking at the breach of the code, you'd be looking at the code itself, and you'd be applying your findings of fact to the breaches of the code. And then once you've reached that stage, you would then go on to consider whether or not a sanction is appropriate, and indeed what that sanction would be. And then just to finalise it, obviously, whoever is subject to the complaint would then be written to formally by the Standards Committee with the outcome of their findings. So I don't propose to go into it in any more detail. It is, as I say, it is a fairly lengthy document. It's very difficult putting things together when you actually haven't been through a process yourself. But I have spoken to monitoring officer colleagues of mine that have been through the process. They've advised me as to which parts they found useful to add. For example, you know, if a member fails to turn up at a hearing, what do you do? Because you wouldn't want a hearing to be dragged on for months and months and months just because a councillor is failing to turn up. So I don't propose to add anything to that, but if you've got any questions, then obviously I'll be happy to try and help. But as I say, for me, this is just getting a procedure before you. I couldn't find a previous procedure that Standards Committee had. There must have been one, but it was way before my time. So I've gone back, I've revisited all the legislation, I've looked at good practice in other authorities, and this is what I've come up with. So hopefully we've got something in place in the event that we do need to receive a report from the Ombudsman.
Has anybody got any comments that they may wish to bring up? Mike?
Yeah, thank you, Chair. Tracy, it may be there. I just can't see it quickly. I'm sorry. In terms of the makeup of the panel, if you like, of the committee, is that covered as to how that is made up and who's going to chair it?
That's a really good point. Previously, and again before my time, we did have, and Hugh will correct me if I'm wrong on this, we did have subcommittees. So it wasn't the full Standards Committee, we would set up a subcommittee. I've not put that in because my view was that we haven't got a huge Standards Committee in any event, and it may be something that the entire Standards Committee would want to sit on, as opposed to creating a subcommittee of the Standards Committee. That's something that I'm open to, you know, to discuss with you if you would prefer to put something in there about a subcommittee. But as I've drafted this, it just simply refers to the procedure, and we haven't. It doesn't touch upon whether or not it should be the full committee or the subcommittee, or a subcommittee. Sorry.
Yeah, and I'm not asking, I don't think, for a subcommittee. I just wonder if our intention, if we were ever called upon to say that the chair of the Standards Committee would chair the hearing, maybe we should say that. Do we need to say how it's made up so that it has a particular quorum? I'm thinking on my feet, Tracy, which is always dangerous, but I just wonder whether we should cover it. I don't have a strong view as to how we should cover it. Would there be any, and I'm asking this genuinely in front of the councillors, I don't know the answer to the question, would there be any conflict if, I don't know, the leader of the council was before the committee, for example? Then is it fair to ask our Labour colleagues to sit on the panel to discuss? You know, I don't have a strong view on that. It's just a quick thought going through my head, really.
Just two things by way of response to that. In terms of how the committee would be run in terms of quorum number and chair, etc. If it was a full committee considering the hearing, it would be run as per the way we run them today, for example. So you would have, the chair would be Jill Bridges, then the quorum number would be the same for the quorum number. Also the makeup in terms of the lay members and the non-lay members would be exactly the same. It would only differ if you set up a subcommittee, and that subcommittee would have to comprise a certain number of members from the main committee. Okay, so you know, we could discuss that going forward, but certainly in terms of how it would work, that it would be your normal rules that apply to your Standards Committee. In terms of the second matter about if it were, for example, the leader, then that would be up to individual councillors as to whether or not they felt that they had a personal and prejudicial interest by applying the code of conduct. So it was whether or not they felt that they were personally conflicted out of it, or whether in fact that, you know, they wouldn't be able to approach it with an open, fair, transparent mind and an open mind. So that would be up to individual councillors. We wouldn't be able to stop them. It would be a matter for them.
That's helpful, Tracy. Thank you.
Has anybody else got any viewpoint as to
Michaela?
Michaela? Oh, thank you.
Thanks, Phil. Hello. Yeah, I was just wondering, Tracy, really about legal representation. Paragraph 3.4, it talks about legal representation. I was wondering, I mean, I suppose if you haven't done lots of hearings, then you wouldn't know what the norm was for people, whether they did bring legal representation or not, or whether they had a lay representative. I was just interested in that point.
I think in other authorities, I think they. I'm trying to think of the one in Cardiff and whether or not I think he might have had a barrister representing, but I don't know whether it was at this stage or whether, because I think no, actually in that case he was referred on to the adjudication panel for Wales. So I think in that forum he was represented by a barrister. I don't actually know, Michaela, whether or not they turn up with legal representation or whether they'd have a lay member representation. It would depend on the individual councillor, I suppose, and who they wanted, if they wanted to have a representative turn up. Yeah.
Yeah. Okay. So there are no rules, because, you know, for example, say it was, you know, an employment matter, an internal employment matter. Obviously, you're not allowed, I don't think, to have a legal representative. You have I suppose, a trade union official or a lay representative, don't you? So there's obviously no rules barring actual legal representation.
No, and I'd be very hesitant about putting something like that in this procedure, actually. So saying that people can't be represented with a legal officer or a lay member, because, you know, there are other factors that you might need to take into account, particularly around equality issues as well. So I'd be very hesitant to put something in there stopping people having representation. And of course, the issue you think about, not so much with the standards committee, but certainly with the adjudication panel for Wales, some of the sanctions are quite severe.
Yeah, that's interesting. And can I just ask you about the is it the Local Government Act that applies to the guidance about hearings in whether they're going to be in public or private?
Yeah, there's sorry, about whether or not they're public or private.
Yeah.
Or suggest that the legal background generally, or just in terms of whether it's...
just wondering. So I think paragraph 7 refers to guidance, that the panel would seek guidance regarding whether the meeting would be in public or not. I'm assuming that guidance is as per the Local Government Act guidance, is it?
Yeah, if you look later on in the agenda, actually, we've got agenda item 4, we've got exclusion of the public. Yeah.
So that is the same guidance, yeah?
So it's the Local Government Act 1972 as amended, and it sets out the legislation. Yeah. The guidance that I refer to in paragraph 7 is very much guidance of the monitoring officer.
Yeah. Okay, that's helpful. Thanks very much.
Yeah, and it's going to clearly be a consideration of the standards committee whether they hear matters in private or whether they go into open session. It is an issue which is quite contentious, actually, or has been contentious in the past, particularly in England.
Okay, thanks.
Anybody else wish to bring up any items in relation to this? No? Okay, so in which case, what are you asking us to just take it and comment on?
So on page 1, there is a recommendation set out there, and that's for the Standards Committee to approve the hearing procedure, which is attached. So I think all we're asking you to do is to approve that hearing procedure. And I think the issues about whether or not it's a full committee or a subcommittee, I think those are issues that we can take up further.
Yes. So would you wish for me to request?
If you're all happy to vote either by a show of hands or by pressing your hand button.
See him.
Yeah.
Councillor Thomas,
Yep, there you go.
all in favour?
That's
I
everybody.
think that's everyone.
Yes, thank you very much. Thank you. Thank you. Item 4. Yes, exclusion of the public. Let's see back again, Tracy.
Yeah, so the monitoring officer advice is to exclude members of the public while we're considering the dispensations that are requested. Obviously, you've got a number of application forms there. They do refer to some confidential information about family members and names, etc. So my advice is to consider these without the public being present.
Chair, I have to leave the meeting now. This is Mike Lewis, so I'll come back for item 5. Thank you.
Call you back.
Thank
Okay.
you.
I'm just going to stop recording now then, everyone.